Hey guys, today we will discuss the administration bond and sureties in the context of letters of administration. Now, as you are aware, when a person dies without a will, his family members have to obtain this thing called letters of administration in order to get his assets and to distribute it in accordance with the Interstate Succession Act. Now, it is important to note that if you die with a will, the executor that you appoint in the will, you usually appoint one or two or three executors, the executor can simply apply for a grant of probate without giving a bond or sureties. A bond is something like a guarantee, and a surety is like a guarantor. So this is another benefit of doing a will. You don't have to provide a guarantee or a deposit with the court to ensure that you carry out your duties correctly, you don't steal money, whatever. So now, all applications for letters of administration to the family division of the High Court means above $5 million. All applications for letters of administration above $5 million require the administrator to execute an administration bond and to provide two sureties, that means two guarantors, unless he can find reasons for not doing so. If the letters of administration is taken out with the family justice courts, that means the assets are less than 5 million, paragraph 68 of the family courts practice directions require an administration bond and two sureties to guarantee the proper performance of the administration of the estate under certain circumstances. For example, where the estate exceeds the value of 5 million, you cannot deduct debts. So for example, if the value of the estate is 7 million, but there are debts of 4 million, which in other words, the net amount is 3 million, you still need to go with a bond because the asset value is more than 5 million. So that's when you need a bond and two sureties. Second scenario, where there is a minority interest in the estate. That means the deceased, one of the beneficiaries are below 21 years old. So the court wants a bond and two sureties to ensure that the administrator doesn't do hanky-panky, steal the money belonging to the child and run away, la 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 la. Third scenario, where there is a life interest in the estate. A life interest simply means that somebody gets to stay in the house or enjoy the property for the duration of his life, and then after he dies, it passes on. Number 4, when one of the beneficiaries under the Interstate Succession Act, who will inherit the deceased assets because he didn't do a will, one of the beneficiaries lack mental capacity under the Mental Capacity Act. Fifth example is where the grantee of the letters of administration is a creditor of an estate. That means the deceased owes money to the person taking out the application for letters of administration. For the case of sureties, the value secured should be the gross value of the estate. The sureties, that means the two guarantors, cannot use protected property, which is under Section 51 of the HDB Act for the purpose of justification. In other words, if you have to become a surety, you have to give like a collateral like that. You cannot use your HDB flat, even though it's worth $1 million, as part of the surety, the bond or whatever. So because of this requirement of having to give a bond and finding two sureties, two guarantors, there's a risk of embarrassment or hardship for the applicant who's taking out the letters of administration. He has to go around, family members, relatives, shopping around, asking them to be, sureties. I should highlight though that there is a procedure in court known as dispensation of sureties. That means the applicant, the person who applies for the letters of administration, will make an application to the court to waive the requirement for sureties. If the administrator wishes to apply for dispensation of sureties, he must satisfy the conditions and requirements of paragraph 69 of the Family Justice Court's practice directions. He has to take out a summons. A summons is essentially an application, a court application. He has to take out a summons applying for the dispensation of sureties pursuant to Section 29(3) of the Probate and Administration Act. The summons must be supported by an affidavit signed by all the administrators and co-administrators stating the date of death of the deceased, the efforts made to find sureties or why sureties cannot be found, who the beneficiaries are, their share entitlement to the estate, the ages of the beneficiaries, and whether the adult beneficiaries consent to the dispensation application. The consent of all the adult beneficiaries to the dispensation of sureties have to be in writing and have to be duly signed in the presence of a solicitor or any person whom an affidavit can be sworn or affirmed, essentially a commissioner for oaths. And the consents have to be filed together with the application for the dispensation of sureties. The affidavit should also state whether there are any beneficiaries who are minors or beneficiaries who lack mental capacity within the meaning of the Mental Capacity Act. It should, if there are any, it should state the names of such beneficiaries, the relationship of the administrators, the co-administrators to such beneficiaries, and the steps that will be taken to protect the interests of such child beneficiaries or beneficiaries lacking mental capacity. Because if you lack mental capacity, there's a chance that the administrator can run away with the money. The affidavit for the application should also state whether the estate has any creditors for debts that are not secured by mortgage. That means unsecured debts basically means no collateral was given, like you borrow from a money lender, fast credit, or whatever. And the affidavit should state the amount of debt owing, whether these creditors consent to the dispensation application, and any other information which may be relevant to the application. Now, it should be noted that it is a very time-consuming process to apply for the dispensation of sureties, and applications are not automatically granted as of right. So, an application for the dispensation of sureties can potentially add substantial costs to taking out a grant of letters of administration. It's quite expensive. It can cost $2,000-3,000, and it will also delay the process. Therefore, you can avert this requirement for sureties and a bond by simply spending $200 or $300 to make your own will. So thanks for watching this video on the administration bond and the requirement for 2 sureties when taking out letters of administration.